Hi, I'm McKessy, Chief of the SEC's Office of the Whistleblower. Thank you for your interest in the Whistleblower Program. We are often asked what happens after a whistleblower submits a tip, so today I will walk you through how the investigative process works and your role as a whistleblower. First, when you submit a tip, please make sure you use the form TCR, which is required for you to be considered a whistleblower for this program. It contains declarations of eligibility that you must sign off on. You may submit anonymously and be part of the whistleblower program, but if you do submit anonymously, you must be represented by counsel. When you submit a whistleblower tip, you will receive a TCR submission number. Please retain the submission number for your reference, but don't worry if you lose it. We will always be able to find your TCR by your name. When your TCR is submitted to the SEC, our attorneys, accountants, and analysts will review the data you submit to determine how best to proceed. If it is a matter the Enforcement Division is working on already, the TCR gets forwarded to the staff handling that matter. Often a TCR gets sent to the experts in another division at the SEC for their evaluation. Even if your tip does not cause us to open up an investigation right away, the information you provide is retained and may be reviewed again in the future if more facts come to light and a picture becomes clearer. In any event, please know that each tip received is evaluated very soon after being received by the SEC, and it is looked at by at least 2 SEC attorneys. If we need additional information to evaluate your tip or to assist us in any resulting investigation, we will contact you or your attorney. The best thing you can do to make your tip useful is to provide specific, timely, and credible information. For instance, a general claim that you think your next-door neighbor is committing securities fraud does not give our investigators much to go on, even if it turns out you're right. Our staff will be much better able to pursue an investigation of your tip if they have specific examples, details, or transactions to examine. So the more information and specifics that you can provide us to follow up on, the better. People often call us to ask if they should submit something or submit an update, and we will almost always suggest that you submit it. As I often tell people, you never know what information may be the last piece of the puzzle for an investigation. Additionally, what may seem small or insignificant to you might actually be critical to an ongoing investigation. So what happens if you submit your tip and it causes an SEC investigation? Our enforcement staff will follow the facts to determine whether to charge an individual, an entity, or both with securities law violations. These investigations can take months or even years to be concluded. Further, even after the investigation is complete and the Commission decides to file a case, the case may be litigated, which may mean significant additional time before the case is resolved. So please understand that it can be a long time before a resolution to your matter is final. That said, once a matter in which over $1 million in sanctions is ordered is final, we will post a notice of covered action on our website. You can sign up to receive an email each time we post a new one, and you may also hear from me or someone in the whistleblower office directly to let you know that the case that you reported on has been posted. If you recognize the case you brought, you'll have 90 days to submit a Form WBAPP to apply for an award. We will respond promptly to acknowledge receipt of your application. From there, we will go into the deeper analysis required by the Commission's rules to determine whether to pay an award, and if so, how much. The Commission's rules describe 7 factors that we use to determine whether to increase or decrease the percentage of an award. The 4 factors that may increase an award are the significance of the information provided by the whistleblower, the assistance provided by the whistleblower, any law enforcement interest that might be advanced by a higher award, and the whistleblower's participation in internal compliance programs, as in, if you reported on a company that you currently or used to work for, did you report internally first, and did you participate in any internal investigation? There are also 3 factors that can decrease the percentage of an award. These are culpability, an unreasonable reporting delay, and interference with internal compliance and reporting systems. Please know, however, that even if all of these negative factors apply, you may still be entitled to an award higher than the 10% minimum. You can find more information about each of these factors on our website under the Frequently Asked Questions section. So let's sum up. Please be aware of the following points. The more specific, credible, and timely the information you provide, the better it is for our investigators to follow up on. Please also send in any updates or developments that occur. Understand the positive and negative factors the Commission considers in determining an award percentage. And finally, please be aware that the securities laws can be very complex and that SEC enforcement actions can take years to be finalized. Thank you very much for listening to me today. If you have any questions, please call us at 202-551-4790 or visit the Frequently Asked Questions section of our website, www.sec.gov/whistleblower.